Welcome everyone to our latest webinar on third-party arrangements. We've had a number of questions on this issue and continue to get questions, so we thought we'd provide another opportunity for people to have some interaction and receive some guidance. So what I'm going to do is briefly run through the advice we've given in the past, and I'll talk a little bit about new information we've provided and some new information that's on our website. There will be plenty of opportunity to ask your questions. You can type in your questions in the webinar question pane. We will answer as many questions as we can. We'll do all of those at the end of the session. We can't guarantee we'll get to every single question, but we would hope that in many cases people will ask similar questions. So even if we don't specifically refer to your question, we will be trying to batch questions up and provide answers that will meet everybody's needs. So just to again to reiterate, why has this advice about third-party arrangements been issued by ASQA? So providers over time have indicated that they're unclear about the extent to which third-party arrangements are permitted and what constitutes a third-party arrangement and what doesn't, and other related issues. We've also been concerned, and increasingly over the last year or so, about marketing ostensibly on behalf of RTOs, where particularly it's not clear who the RTO is that's actually offering the vet course. We have received a number of complaints over that period about from people who have signed up for a course and weren't aware at the beginning who they were actually signing up with. And some other complaints have actually identified that the provider who people thought they were being trained by was in fact not the RTO they were enrolled with. Alongside that, we have identified some emerging issues relating to delivery of TAE or training and assessment qualifications by third parties. And in many cases, those are RTOs who have previously applied to deliver those qualifications, but not been approved to do so, but have now been attempting to do so through a third-party arrangement with another RTO. So just to go back to the basics, what does the legislation say? The National Vocational Education and Training Regulator Act 2011, or the NVR Act, is what would be considered the primary legislation. And that piece of legislation describes what is permitted, or in most cases in relation to third parties, it describes what is not permitted. And it authorises the standards for RTOs. So the standards for registered training organisations 2015 are a legislative instrument that sit underneath the NVR Act. And the standards describe how activities that are permitted must be implemented to the extent that the standards cover those activities. So what that means is the standards don't actually authorise anything in and of themselves, but they do actually describe how, as an RTO, you must implement your obligations under the NVR Act. So there are two different areas to this, and the NVR Act treats these two areas differently. And the first of those is the arrangements as they relate to NVR RTOs. And it's important to remember that if any of you are listening that are RTOs which are regulated by the VRQA or by WA TAC, these requirements don't apply to you, as the NVR Act does not apply to your operations. So the NVR Act doesn't explicitly permit third-party arrangements. It doesn't, of course, explicitly forbid them either. But what it does do is it defines behaviour that is not permitted that relates to third-party arrangements. So in section 93 of the NVR Act describes that an RTO commits an offence if it provides all or part of a vet course. And of course, a vet course is a training package qualification, an accredited course, or an accredited qualification, a skill set, or one or more units of competency, all constitute a vet course. So if an RTO provides all or part of a vet course, and that vet course or that part of a course is not on that RTO scope of registration, then that is behaviour that is prohibited by the NVR Act. As it relates to non-RTOs, and it's useful to know in this context that the NVR Act actually treats RTOs differently to any other form of entity. So in the language used throughout the Act, it refers to persons as being someone or a natural person or a corporate entity which is not an RTO. and it uses the term NVR RTO or National Vocational and an NVR RTO, and it refers to those two things differently. In other words, it does not treat NVR RTOs in the same way as it does a person. So the NVR Act, again, does not explicitly implement third-party arrangements with regard to non-RTOs, but Section 116 of the Act does describe that a person, in other words, a non-RTO, commits an offence if it provides or offers to provide all or part of a vet course, and that person is not an RTO. So there are what might be seen as some subtle differences, but they are quite important differences. And that's why we describe those differently in the guidance we've provided and why we describe them differently in the general direction. So what does this mean for RTOs? It means that an RTO may only enter into a third-party arrangement with another RTO, which we would refer to as the third-party RTO for clarity, to provide all or part of a vet course if that third-party RTO has the vet course on its scope of registration. Now, this has been one of the areas of a lot of confusion, which we've attempted to provide further guidance on, which I'll come to in a little while. It is not necessarily required for the RTO that actually seeks to engage another RTO to deliver to have that course on its scope. It's the third-party RTO in this case who is actually providing the course or part of a course. And therefore, when you come back to what I mentioned just briefly, just a moment ago in the Act, the third-party RTO who is offering the course must have that course or partial course on its scope. So for non-RTOs, the situation is slightly different. So an RTO may engage a non-RTO, which we refer to as the third party, to provide all or part of a vet course on behalf of the RTO. So that, again, that non-RTO could be a natural person or a corporate person, and legislation often refers to person to include corporate entities, which may be a shareholder company or a publicly listed entity or any corporate entity of that nature. But in this situation, that entity cannot be an NVR RTO. So in this case, the plain speak language, I guess, is that in this case, the non-RTO is acting as an agent of or on behalf of the RTO in question. And obviously in this case, the RTO that is engaging the third party must have the relevant course or partial course on its scope of registration. So some things that are excluded from third party, some things are very clearly excluded. There are some areas which are slightly more grey, and I'm happy to take examples from people that if you're looking for some guidance about whether your particular arrangement is excluded as an RTO. So one that is very clearly and explicitly excluded is any form of engagement of trainers and assessors as contractors. So whether you engage a natural person or whether you engage a person through a corporate entity, if you're engaging someone to act as a trainer and assessor where in all other aspects beyond the manner in which you engage them, they would be considered a member of staff, then they're clearly and very explicitly excluded from third-party arrangements. So one of the things we've had a lot of questions about is situations where, for example, in a work placement scenario where you use what's often referred to as a third-party report, not to confuse the two issues, but where you have a workplace supervisor who provides things like an observation checklist or provides feedback on the performance of a learner while they're in a workplace. And therefore they contribute to evidence collection. They provide part of the evidence that you use in order to make a decision in the assessment process. Those arrangements are not third-party arrangements. Excuse me. Arrangements where you're accessing facilities. So for example, if you are delivering a fitness qualification and you enter into an agreement with a gym or other similar organisation to use their gymnasium facilities or any of the other facilities, or if you are teaching cookery and you enter into a commercial arrangement with an organisation to provide you with access to their kitchen facilities, those are not third-party arrangements. And one of the areas where we commonly see where people are a little bit confused is where things fall into the area of what would be considered a purchasing or procurement or whatever word you like activity. So where you are, one example of this is an enterprise RTO that engages another RTO to deliver training to their staff, which is not part of their normal activity in terms of acting as an enterprise RTO and providing courses on their scope, where you're simply entering into a commercial arrangement where an RTO provides training for your staff, or in the case of a school, it might be providing training for your students, or activities similar to that. They are not a third-party arrangement. So, as I said, this is a little bit grey depending on the individual circumstances, but it really is about what's the actual arrangement here. Are we actually entering into some form of partnership type arrangement, or something that would be seen as where there's training and assessment being done by both parties? If it's a simple fact where you are paying another provider to deliver training to your staff or to your students, and they are wholly and entirely responsible for the students in relation to that training, then that would be not considered to be a third-party arrangement, and therefore wouldn't fall within these guidelines. So marketing by third parties is an area where we've also had a lot of questions, and there is a bit of interplay in the standards here, which we need to understand. So in order to meet the requirements of the NVR Act, it must be very clear in any marketing that the marketing must be in the name of the RTO that will issue the certification. And that's regardless of whether this is an arrangement between RTOs or an arrangement between an RTO and a non-RTO. It must be very clear to the average person, and importantly, very clear to prospective learners, who is the RTO that will be responsible for the learner's journey and who will issue the certification at the end of that journey. Where that has been a little bit confusing for some people is that clause 5.2 of the standards for RTOs requires that you provide information to prospective learners about any third party that might be involved in that activity. It also requires that you do so in regard to recruitment and so on, and some other activities. But for the purposes of this conversation, you are required to provide the information that there is a third party involved in the process, and so you do need to make it clear that that's the case. But it is really important that to prospective learners, and then using a reasonable person test, that it's very clear who the actual RTO that's responsible. So just in terms of how we're treating this, how ASQA is treating this, we certainly are not in any way specifically targeting third-party arrangements in regulatory activities. We have always considered third-party arrangements where they exist in our activities, and we will continue to do so. But we have no plans in the immediate future or in the foreseeable future to specifically target third-party arrangements in any way. Where they are in place and a regulatory activity is scheduled, they will be considered in the normal course of business. Right across the board for everything that relates to this third-party arrangements, we acknowledge that the advice that we've been providing and the clarity that we've been giving about what are the restrictions and what are the expectations around third-party arrangements, in some cases is new information for people, and it's certainly not been widely understood what these restrictions were. So in that sense, we've been taking and will continue to take a reasonable approach. We do understand that some arrangements that people have had in place with all good intent and in the absolutely genuine belief that they were legitimate, may take some time to bring into line with these legal requirements. We don't want to see students disadvantaged in this process, and we don't want people feeling that they should enter into transition arrangements that severely disadvantage students. So we have actually extended the deadline which we had originally set. So that the deadline for existing arrangements to be expected to come into line is the 1st of January 2020. That's not long away now, we appreciate that. But we do understand that there may be some residual arrangements that need to be continued beyond that period. And if you can demonstrate that you've made all efforts to bring those into line as quickly as possible, keeping the interests of students at heart, then we're not going to have a serious problem with that. So we have collated over the time since we issued this advice. We have been collating all of the questions we've received, particularly through our info line, but also through other sources. We've put those all together, we've analysed them and assessed them, looked for any common themes that might be coming through in that process, and we've attempted to provide answers to as many of those questions as possible. And I'll just run very quickly through those. So you should now be able to see on your screen ASQA's website. And if you go to the very top bar of our website, where you can see the mouse pointer, I hope, you'll see there's a help center there. And you can click on that help center, and it then takes you to an area where we have a significant body of frequently asked questions and other information related to various topics. If you go down to the bottom of that list, you can see that there are a series of questions around third-party arrangements, and that takes you through a significant number of questions, 24 questions, where we've tried to answer all of the queries that we've been receiving. So the first of those, and a bit of what I've been talking about so far, has been the question we've been asked can be broadly characterized as, are all partnerships between RTOs third-party arrangements? So you can see some scenarios there, excuse me. You can see some scenarios there where we've tried to encapsulate the sort of situations that people are asking us about. So we do ask, if you have a question, this would be your first port of call, and think about what your situation looks like and whether you fit into one of those. So around the marketing issue, similar questions have been around, can learning and assessment resources be branded by an organisation other than the responsible RTO? And the answer is yes, they can. We're very much aware that in many cases people are using commercial resources that are provided by not necessarily a third party as such, but provided by another party other than the RTO. And it certainly is perfectly okay, and is often actually a requirement of licensing arrangements for such resources, that you actually maintain the branding of the owner of the resources. So it's very clearly okay to do that. It is important that RTO, that throughout the journey that a student has with your RTO, that they do understand who it is that they're engaged with. So please make sure that you're actually making it clear who it is that the RTO is, and who the learner is engaged with. One area that we've had a lot of questions is about the AQF certification issued, and that is slightly different to what I've just said, that the RTO should be clearly and only the only organisation identified on that certification. The question around implicit versus explicit registration, if you're not clear what this means, there are two ways for an RTO to have vet courses on their scope of registration. One of those is what we call explicit scope, and that obviously covers things like qualifications and skill sets that are actually listed explicitly on your scope of registration on TGA. And the other way is implicit scope. So when you are registered for a qualification, whether it's a training package qualification or an accredited course qualification, although this applies almost entirely to training package qualifications, there are usually core units in that qualification, and then there are elective units in that qualification. And those named some of those electives are named in the packaging rules, but packaging rules often allow you to import other units of competency into that qualification. And it's those units of competency which are referred to as implicit scope. In other words, if you have a qualification on your scope of registration, and that packaging rules for that qualification allow you to import other units of competency, in the context of delivering that qualification, those units of competency are considered to be implicitly on your scope. It doesn't mean you can deliver those units of competency as standalone products, but you can certainly issue them through that implicit registration where they're named or referred to in the packaging rules. So can the name of the third party be included on marketing material? Yes, and I talked about that a bit earlier. In fact, in some circumstances, you are required to provide details of the third party. So you can see that these frequently asked questions have been aimed at encapsulating answers to all of the questions which we've received. And so, for example, one of the questions we've received, and one where there was some confusion on in the early days of this advice coming out, was that it's generally not required for an RTO who is engaging another RTO who has a product on scope to also have that product on scope. But there is a principle in place here that it's not acceptable for an RTO to seek to extend their scope of registration by entering into third-party arrangements. So you can see there's a range of questions there. If you aren't able to get your questions answered through that mechanism, you can always contact our, sorry, bit of incompetence there. Sorry, I'll just navigate my way through. You can certainly contact our info line, and our contact details are on our website. And they're also now on the slide in front of you. So if you have specific circumstances and you're looking for some clarity, we're more than happy to answer those questions. Obviously, the more clearly you describe your situation, the easier it is for us to give you a positive answer about whether or not your circumstance constitutes a third-party arrangement. So we'll start to look through some of the questions we've received now, but do please keep bringing those questions in. Answer. So a question from, answer the red one. Sorry. So the question here from Sean saying, so the words training is performed under the auspices of XYZ RTO number XXX, is it okay to use? So it may be in certain circumstances. What we have seen in the past is often kind of people presenting these arrangements as here's the question is this organization ABC is offering this course, and somewhere in the fine print at the bottom of a website or in similar sort of circumstances, this course is delivered under an arrangement with RTO number AB number 123. And again, I talked before about a reasonable person test and making sure that the average person, when they look at your information, that it is immediately very clear to them who is the RTO in question. So where you have the non-RTO or the third party front and center saying this is a course that's being offered by organization ABC, and that organization isn't the RTO with the product on scope, then you need to almost reverse that and make sure that it's the RTO who is front and center and who is very clearly the organization that is offering and providing the course. Question from Chris. So would ASQA provide a sample third-party agreement to provide the minimum information that should be included? So across the board, we've kept away from providing template documents or sample agreements or other sample documents like this, for the reason that there are so many variables that are in place with RTOs, and what we don't want to see is a kind of cookie cutter approach or one size fits all approach taken to these things. We do have some information on our fact sheet on third-party arrangements, which is on our website, and that does give you some guidance about minimum information that should be included. Obviously, with your specific circumstances, you should consider what other information should be included or whether all that information is in fact relevant. We don't want to see these agreements become 50-page agreements full of legalese and so on. There should be a document that works for you and that works for your third parties, and that makes sure that that the minimum requirements are met, that your third parties, for example, are clear that they must cooperate with ASQA in the conduct of any audits, that they may be provided to provide information, that ASQA may, following arrangements being made, want to visit those third-party premises where training and assessment might be delivered in those premises. So at this stage, we don't have any plans to provide a sample agreement for the reasons that I've outlined. But again, more than happy to provide guidance if you think if you have questions about whether should I include this information, do I have to include that information, for example. So the next question from Joanne saying that can a third party advertise a course that they train and deliver as long as it clearly identifies who the RTO is? And I think that really encapsulates what we're trying to get people to understand in this space, is that if you use, it's very easy sometimes for people like the RTO themselves, or we see this sometimes too, to look at information and think, oh, I can see what's going on there. But you do need to take a little step back and say, if I didn't know exactly what was going on, if I was just an average person on the street, would I understand who the RTO was in this? And it may be useful in that context to get someone outside your RTO to review that. I'm certainly not saying you're required to do that, or that we'd expect you to show proof or anything that you've done that. But that may be a way of getting some objective feedback on, is it really clear to the average person who the RTO is in this scenario? So Joanne's asked a question saying, can a third party host a website that sells a course they sell, train and deliver, or does the website have to be owned by the RTO? Thanks for the question, Joanne. That's actually a good question. One of the questions that I had someone ask me at a conference a little while ago was around domain names and around the ownership of websites. So it really doesn't matter who owns the website. There's no restrictions on what a domain name or any part of it, a domain name or URL might be. It really is about the content rather than the specific address or the ownership of the website. None of those things really matter in terms of presentation to the public. Those of us that have been around the IT space for a while will remember the days when domain names were everything, but much less important these days. What's important is the content that's displayed to the public on that website. So Adrian's asked, as a third-party RTO delivering a unit for an RTO, who is required to notify ASQA? My understanding is it is the RTO, not the third-party RTO. Is that correct? And that's absolutely correct, Adrian. So the organisation that's required to notify ASQA of the arrangement is the organisation that has engaged the third party, regardless of what sort of arrangement that is. So we've mentioned previously that we've been doing some enhancements to ASQAnet, and I'm sure that many of you will be extremely glad to hear that. But one of the areas that's being enhanced is the management of third parties, and you'd be aware that the arrangements for that and how that interacts with ASQAnet have been less than ideal for some time now. So the next release of ASQAnet will actually allow RTOs to directly through the ASQAnet portal, which will be known from that point as ASQA Connect, to actually actively manage all of their third-party arrangements. So they'll be able to enter new third-party arrangements, they'll be able to update existing arrangements, and they'll be able to notify that existing third-party arrangements have ceased. There are some complexities we've encountered in actually rolling out that new update. At this stage, we are expecting that update to be available in the second or third week of December. The IT environment in which we operate as a government organisation presents some security challenges for us sometimes in updating new systems, and that's where we're at the moment. So we will be notifying providers as soon before that is released and when it's released, and there'll be information about how to use that new functionality. It does include many other enhancements, not only third-party arrangements, but we do appreciate that it is somewhat clunky to notify us of third-party arrangements at the moment. So we're comfortable with people holding off until that new release is available to you, because that will make that process much easier. So Sashin has asked a question saying, we are CRICOS registered and do not have any third-party arrangements with another RTO. We have agents recruiting students for us. Will this be considered a third-party arrangement? The answer to that is yes, they are considered third-party arrangements. And one of the complexities that brings in the CRICOS registration space is that you do need to notify ASQA of these third-party arrangements, and you also need to enter those agent details into PRISMs. If you're not a CRICOS registered provider and you don't know what PRISMs is, you don't need to panic unless you're a CRICOS registered provider, which means a provider registered to deliver to overseas students. You don't need to worry about that. But you do need to enter those into both those locations. I would expect mostly that your contractual arrangements with agents would also address the requirements for written agreements with third parties. You don't need to have separate written agreements as a third party under the NVR Act, as well as an agent under the ESOS Act. We would expect that you would have an agreement that covers the requirements of both of those. So Kirsty's asked us to provide some examples of what procurement or purchasing arrangements might be. So I mentioned earlier, one of those that's been brought up to us a number of times was an enterprise RTO who is seeking to have training for their staff, which is not part of their normal business as usual approach of training, for example, apprentices within their organisation. But in that scenario, for example, they may seek to have other staff trained in areas which they don't have on their scope of registration and which they don't wish to deliver themselves as an RTO. So they may arrange for an external RTO to come in and deliver that training to other staff or to their staff. And clearly that's not within the bounds of a third-party arrangement. In that case, there's generally no involvement with the enterprise in the delivery or assessment, although in some cases they may act as a workplace supervisor, for example, which I mentioned earlier, but generally those arrangements are not third-party arrangements. They're simply a commercial arrangement for an organisation to pay an RTO to deliver training to their staff. And the same situation as if the organisation was not an RTO at all. Any companies regularly engage RTOs to deliver training to their staff, and this is no different. And a similar example is where a school is an RTO, and they do the same thing, where they may wish to have one or more of their students undertake a course which the school doesn't offer, and where they engage an external RTO who does the entirety of the delivery and assessment, although some of that may occur in the school premises or there may be some resources of the school used, but where the external RTO is entirely managing the arrangement and entirely responsible for the students. So, for example, ASQA does from time to time procure training from RTOs. We're not an RTO ourselves. We don't issue any qualifications. We don't provide any nationally recognised training in our own right, but we do often procure training from various RTOs to train, for example, our auditors and sometimes other staff. And those are simply commercial arrangements to enable staff to be developed through the involvement of an external RTO coming into the organisation. One example of that might be if you are in a position where your staff need to have CPR training, for example, and that's not something that you deliver, where you might engage an external RTO to come in, deliver that training and assessment to your staff, issue the certification to them, and you don't have any involvement in that other than to, I guess, a process of selection, but to engage the RTO to pay them for their services, and they're responsible for the students throughout their journey. So Ruth has asked a question, Ruth Garner. No relation to me. I'm very confident of that. Can I engage trainers that are contract trainers and they aren't a partnership, even if they're employed by another RTO? Yeah, certainly you can, Ruth. So we're aware that in many cases, trainers and assessors, particularly those who operate on a contract basis, work for multiple RTOs, and there's certainly no reason why you can't engage a person as a contractor, regardless of how many other RTOs they may also be contracting to. So Eileen's asked a question about the interplay with funding arrangements. So the Skilling Queenslanders for Work funding scheme, where the training is required to be delivered by an RTO, but the agency who the Queensland government engages to administer that funding is not an RTO. So does this arrangement need to be a third-party arrangement? This is Eileen, I thank you for the question, because this is a somewhat complex arrangement. And to some extent, it depends on how that particular Skilling Queenslander for Work agency has procured the training from the RTO. In some cases, those organisations have a very close involvement with that. So it's really a question of looking at what is the involvement of the agency that has been charged with administering the funding on behalf of the Queensland government. To what extent are they involved in actually recruiting students to direct to that particular RTO? In some of these cases, they are engaging multiple RTOs and allowing students to have some choice about which RTO they go to. In some cases, they are working closely with another RTO. All of those circumstances are fine, and obviously we would expect that people should act in this area with the best interests of the students at heart. So unfortunately, it's not a matter of saying, yes, in 100% of cases, this is a third-party arrangement, or no, in 100% of cases, it's not. It's really a matter of looking at what are the specific arrangements between the two organisations. And that matrix, which I showed you on our website, might help you with some guidance about that and what involvement each organisation has. So we've got a question from Joanne saying, what does marketing must be in the name of mean? So I've talked a couple of times about that reasonable person test or the average person test, and I know that's I know that people are often in this area looking for really clear and precise answers, and I wish that our world was as simple as that. We're all aware that in many areas our world is somewhat complex. So it really does come down to that average person test or the reasonable person test. And again, think about an external person to your RTO or a person outside the vet sector perhaps who would look at that and say, yes, I understand when I look at this material who the RTO is that's involved. I do appreciate that there's a certain amount of desire to protect people's brands and sometimes people's reputations that they've built up over years. And there's certainly nothing wrong with, and in fact, as I mentioned earlier, it's required to identify third parties that are involved. But if you just take a step back and look at your material, whether it's a website, whether it's flyers, whether it's advertising in print media, if people still do that, just look at when you look at that, who is the RTO, who is the organisation that jumps out and tells me this is the organisation that's offering the course, and this is the organisation on whom I will be embarking on my journey towards receiving certification, a qualification, or similar. So Amelia, there's a question. The next question is around skilling Queenslanders for work agreements. So Amelia, if you don't feel like I've answered your particular question, if you could perhaps specify what your question might be. If I haven't answered it in the answer that I gave to Eileen. Ali's asked, can a school publish on their website the RTO's flyer for a course? I think that this is a good question. One of those areas where it sometimes does start to get a little bit grey. So, and I'll take a little bit of, make a few assumptions here. So I think this is an example where a school may be wanting to promote a course offered by an external RTO that has no connection otherwise with the school, so that their students can undertake that course either as part of their, for example, in Queensland, leading to a Queensland Certificate of Education or the equivalent in other states, but where the school isn't intending to have involvement in the delivery of it. I think it's perfectly okay for schools to provide information to their students and to their school community about courses that might be available to them. One example we've had in this area is a school that wanted to offer courses to the parents of students, which was a new one for me. And I think that's perfectly okay. And it just making clear that it's not the school that's offering the course, that you are providing information to the school community as a service, as an information service, and that the school is not necessarily promoting the course on their own behalf. So we have a range of questions here which relate to ASQA, and I'll do my best to answer all of those questions. So generally, do the delivery locations of third-party companies need to be listed on ASQA? And I don't think that is the case. I think you do have to give an address for the third party, but there's no requirement for you to provide, there's certainly no capacity to provide multiple addresses for a third party at this point. I don't believe you do have to provide delivery locations in all cases. Yes, if you are registered on Cricos, you will of course need to make sure that all locations where you deliver courses to overseas students are listed on PRISMs, and there is provision there for you to notify us of locations which are operated by a third party, as opposed to locations which are operated by your organisation directly. So do we need to inform ASQA every time we enter into a new agreement? So if you enter into a new agreement with a new agent, then certainly, yes, you do need to notify us. I think this is referring largely to overseas recruitment agents. So if you already have an agreement with an agent and you don't have an end date in your ASQA notification of that, and you, for example, renew that agreement and the arrangements are the same, then you don't need to re-notify us of that. If you were, of course, to cease an arrangement with an agent, you do need to notify us that that arrangement has ceased. But if you're simply renewing an existing arrangement, you wouldn't need to notify us again. But you do need to notify us about any new arrangements you enter into with a new agent, or perhaps a new arrangement where you haven't previously had one with an agent you've worked with before. There's a question about the responsibility of the RTO to report the third-party arrangement. Can a third party check on ASQA if their arrangement has been reported? That's a very interesting question for so we, as a matter of principle, with all information relating to RTOs that is not otherwise publicly available, we don't release information about RTOs to any other party unless we're required to or permitted to by law. So there is certain information which is published, of course. TGA and or the CRICOS register publishes information about providers. We do publish certain information about decisions about providers and other information. But if a third party organisation contacted ASQA and asked us to provide them with details of information that's provided about them, we would refer them to the Freedom of Information process. And if there was a request through an FOI process to release information about third-party arrangements relating to an RTO, we would go through a consultation process with the RTO before we would agree to release that information. So a question from Michelle, will we be able to access previously submitted third-party arrangements under the new ASQA Connect? It's good to see you using a new name, Michelle. The new ASQA Connect portal. Yes, you will. All of those existing arrangements will be imported into the portal as part of this the change over to the updated ASQAnet system. A question from Gary about whether we can get a list of education agents that you've notified about. You certainly can contact ASQA and ask for a list of those. It may be more useful for you to just, if you can hold off for a few weeks, when the new Connect portal comes online, you'll actually be able to see all of the arrangements you have in place, including any prior arrangements, and you'll be able to then directly manage those arrangements through ASQAnet. So if you do urgently need a list of those arrangements, you can certainly contact the info line and we can provide you with that. But certainly in the near future, you'll actually be able to see that in real time through ASQAnet. So we have a question from Zamarak saying that, that sections 93 and 94 of the NVR create an offence for an RTO to deliver something that's not on its scope. So Zamarak saying these sections do not restrict an RTO from appointing an agent to deliver training and assessment on its behalf. So ASQA and Zamarak's putting forward a view that ASQA's reading of these sections appears to be incorrect. So thank you for putting that forward, Zamarak. Before we released this guidance, we did very thoroughly test the actual meaning of the NVR Act in this space. And the guidance we provided was actually based on advice that we've received from the Australian government solicitors. So we are very confident that we've correctly put forward what the NVR Act allows and doesn't allow. There's been no case law in this space, as you would be aware, but we are absolutely confident that we are not misinterpreting the Act in any way in this area, and we've been very, very cautious to make sure that we don't go beyond the bounds of what the NVR Act allows or doesn't allow. So a further question from Zamarak, so saying that questioning the advice that I've given about the differentiation between between an NVR RTO and a person in the Act. And Zamarak, you're correct that an RTO continues to have all the legal rights and obligations that a person has, of course. The NVR Act doesn't take away any rights or any of the rights of a person in any way, and doesn't purport to either. However, there are additional obligations that an NVR RTO has that the NVR Act does confer on an RTO. So it is important to understand that, and thank you for pointing it out, that we're not suggesting that people are deprived of any rights by becoming an NVR RTO, or that the NVR Act actually takes away any of their rights under the Constitution or under any other law. So, so a question from Tim. So Tim is saying that recently they were provided certification document advice that RTOs may customize certification documentation, can include additional information such as the name and or logo of a third party. Yes, thanks, Tim. We did previously have some advice that we subsequently found to be incorrect, and so we removed that advice approximately 12 months ago when we realized that specific piece of advice had been was not well formed, and that actually was providing advice to people that they were permitted to do something that that actually wasn't permitted. So slightly embarrassing, but thank you for pointing it out. It is useful for us to make it clear that that there was previously that advice in place, and so we would certainly not have any issue with providers that had previously acted in accordance with that advice. But of course, we now would expect people to act in accordance with advice where that's been corrected. So Tim's got a follow-up question. Will we be providing advice on other information that RTOs may add to statements of attainment? For example, a class or name of machinery that has been used in the course of assessment is commonly added to statements of attainment. Is this still permitted? And yes, that is clearly foreseen in the AQF, and it does actually provide somewhat general advice, I must say, but it does provide advice about the capability to issue that. And I know that is important, particularly in the resources sector, for example, where employers are very keen to understand the context in which a learner has been assessed. So I just lost my place a little bit here. So a question from Usama saying, is the person who refers students without involving any assessment or results considered a third party? So I think this is a question about recruitment of students. So a person who is recruiting learners on behalf of an RTO, whether or not they have any involvement in training and assessment, is definitely considered to be a third party. So these people and organisations are sometimes referred to as brokers or agents. So anywhere where a person or an organisation is recruiting in the marketplace and acting on behalf of an RTO to recruit students to undertake courses, that is definitely within the bounds of a third party arrangement. And that needs then means of course that needs to be notified to ASQA, and there needs to be written agreements in place. So a question here from Michelle. How does this impact on websites that advertise multiple RTOs or say RPL brokers? Thanks for that question, Michelle. This is an area where there's been a lot of concern expressed to us in the space of third parties. And there's certainly nothing wrong with organisations acting on behalf of multiple RTOs and seeking to recruit learners into one or more of those RTOs through websites. But it does need to be very, very clear in all circumstances who the RTO is that's actually being promoted in those circumstances. Just excuse me. Sorry, my voice is getting a bit dry. So there are a number of organisations who do promote multiple RTOs, and they sometimes promote RPL or assessment-only pathways for those RTOs. In all those cases, it does really need to be clear that there is that to any prospective learner, who is the RTO that's in question. And I do appreciate the challenges there, where, for example, there are multiple RTOs offering the same course, and that organisation is promoting those RTOs equally. So, but it's not that difficult to set up dynamic content on websites to present this information in a way that does comply with the NVR Act and with the standards for RTOs. And it is really important that it is really the RTO that is front and center. So it's not a fact of people can't do that, but they do need to be very careful about how they do that. And we have received significant numbers of complaints about organisations that are not doing this correctly, and we have been in touch with a number of those organisations to get them to correct their practices. So Usama, you've asked another question about, I think this is an important question, although it's not a common situation. We have, this is a question about people advertising that they're a third party to an RTO when there is no agreement in place. We have seen this happen a few times, and we have had RTOs contact us concerned that someone is advertising their RTO and they have no knowledge of that organisation. They don't have any agreement with them. If you do come across this situation, please contact us immediately. That would be of significant concern to us, and that is a very clear breach of the legislation. If someone is offering a course and they're not doing it on behalf of an RTO, we would take that very seriously. So if you do come across that, it's very useful if you can capture screenshots of that information and provide as much information as you can to allow us to investigate that. So Joanne's asked a question which is about generally about mixed types of training being advertised collectively. So can we have VET courses delivered under a third-party agreement with our RTO partner? So I'm taking it that this is a non-RTO organisation, as well as non-VET courses on the same website, or should they be separate? So thanks, Joanne. Yeah, it isn't uncommon for organisations that operate as a third party for RTOs to also be operating outside the nationally recognised training space, and there's certainly no problem with that material existing on the same website. It is very, very important those are clearly separated though. One of the areas where sometimes people get caught out on this is applying the nationally recognised training logo in a way which suggests that other training that is not nationally recognised is also comes under that recognition. So it is important to keep them separated on a website, and we do appreciate the challenges, for example, in social media, where sometimes material can be separated from where it came from and presented in isolation. We do understand sometimes the challenges that come up in that space, but what we do look for is that you've made reasonable efforts to be very, very clear about what is nationally recognised training and what is other forms of training, and be very clear that that it's clear to the average person that training which is not nationally recognised training isn't represented as such. Often this is done inadvertently, and it's through the way that websites get presented or the way that information gets presented on social media, where it sometimes is taken out of the context that it's been designed for. So it's worth testing that if you have concerns about your own organisation, making sure that you're not inadvertently misrepresenting that. So it's worth testing your website in various contexts to make sure that that's not happening. So a question from Andy saying, what's stopping RTOs simply adding the name of a third party to their list of the RTO's training names on training.gov.au? To me, this seems like a risk as far as I can take there would be nothing stopping RTOs from doing this. Yeah, thanks, Andy. That's it is something that we were aware that might be an approach that some people might use. At this point in time, there's actually nothing to stop RTOs from doing that. I think you're absolutely right that it's a risk, and I think the risk is there to the RTO, because when you do that, you're actually tying that name to your reputation. And in the overwhelming majority of cases, there's probably no issue with that. And I'm sure that if you were engaged in a third-party arrangement with someone, you are comfortable with them using your name and you're comfortable with them representing you, and therefore you're comfortable that they don't present a risk to your reputation. But it is a risk if you fix that name to your registration in a public sense, because once that's listed on TGA, it's listed there forever, even though it might be in the historic information. That trading name would always be linked back to your record on the National Register. One thing that that is happening in the ASQA release that I mentioned earlier, though, is that in terms of trying to make things a little bit more streamlined and keep our records as accurate as possible, we will actually be connecting ASQA to ASIC systems, and that means that unless you have an ASIC record of your organisation actually owning that business name, you won't be able to list it on the National Register as one of your trading names. So that'll mean that people won't have to keep updating trading names when they commence using new ones and when they cease using old ones. That process will happen automatically. So that'll come in mid-December or so. So actually that risk will be addressed in that case anyway, because unless the RTO actually owns the trading name, they won't be able to use it. And in terms of representing themselves on the National Register. So what about a question from Sagar that they've left? So Christie's asked a question saying, do we need to have an MOU in place for a business that markets on our behalf? And yes, you do. So if an organization is marketing your courses, or in other words, they are recruiting prospective learners, they definitely would be considered a third party. There are some circumstances though where pure marketing arrangements would not be a third party. So if you think about, for example, Yellow Pages, I think most RTOs have an entry on the Yellow Pages. Yellow Pages is not a third party to your organization because they're simply listing your organization in a directory type arrangement. And there are various other websites around that have a similar arrangement where they're more of a directory. There are lots of advertising hosting arrangements such as Google advertising and other similar advertising where material may be hosted on other parties' websites, which is marketing your organization. Those arrangements are not third-party arrangements. Clearly, you have little control over where that information appears in some cases. And where it's simply advertising your RTO and therefore directing people to your RTO website or to another website where your RTO actually promotes specific courses, those initial arrangements to have that advertising would not be considered as a third-party arrangement. So I do only have another minute to go, so I haven't been able to get through all of the questions, but so I'm just trying to pick one of the questions that has been commonly asked. So Brian's asked a question about what if the school then receives a payment from the RTO? So I think this is an issue or a question that I can answer more broadly than just a school. So in the context of where a school or another organisation is providing information to the public or to a particular group about courses that are available, and then people are enrolling with that RTO, it really doesn't matter whether they receive payment for that referral. It's about the nature of the referral. So how we've described this in some of our information is where there is simple one-way communication. In other words, where you're simply presenting information about a course, we don't consider that to be a third-party arrangement, whether or not there's payment one way or the other. But if you are actually interacting with prospective learners, in other words, if you're answering questions and providing guidance about courses and so on, then that becomes a third-party arrangement. And again, it's irrelevant whether or not there is payment in either way. So it's really about the way that the interaction takes place rather than whether there are payments in place. So I'm really sorry I couldn't answer more of your questions. I have done my best to try and provide answers to questions that are as general as possible and where multiple people are asking. We have captured all the questions that you've asked. We won't be responding individually to those questions, but we will continue to review the frequently asked questions and other material we have to try and make sure that we are responding and providing information to everybody that has questions in this space. So have a look in the next week or so at that frequently asked questions and we'll get some updates done on that. If you do continue to have specific questions, please feel free to contact our info line. The details are on the screen. An email is generally best for those sorts of queries. And if you can provide as much information as possible, we can get you a much more specific and perhaps a better quality answer if you can be very specific about your questions. So thank you very much for your time, and I hope you have a good week and all the best with your RTO and with your training. Thank you.